I te mea tuatahi e hoa nei hana, ka nui te mihi ki a koe mo tō kōrero whakawātea, tō haka whakawātea kia taia e au te tū ki rungi tēnei a tāmira e muri o tēnā kōrero mō rangi awhia. Nā reira, ka nui te mihi ki a koe. Ka nui te mihi hoki ki a koutou katoa kua whakaraui ka nei, ki tēnei ruma, ki ruma ke, no ngā te moitonga en te roke kā ahau, ki tērā taha o ki te West Coast. So kei te pai, I'm on the East Coast, e nai nei, kei te pai tērā, te nui hoki o te honore māku, te tū kei mua i a koutou katoa. Ki runga i tēnei whenua kōrero. Nā reira, tēnā koutou, tēnā tātou katoa. So the title's a bit flash. I'm not entirely sure I do this. Religious and spiritual aspects of Tikanga Māori and its interface with the settler legal system and exploration of Rāhui. I can't promise to entirely encapsulate the promise of that heading, but I'll give it a little bit of a crack. I've got a few things I want to do today. I want to start off with a pretty obvious prelude that locates this kōrero in the context of the place where we are now. I want to talk about the dangerousness of the sacred and give a couple of examples of that, because that's really relevant to the kōrero that I want to get onto in regards to Rahui. I want to talk about Rahui largely because we've completed a pilot research project at Victoria University, Te Herenga Waka. The first step to designing and creating a digital Māori resource to enable law students to learn how to understand tikanga Māori as they make their way through the law degree and become lawyers, thinking to all the wonderful things that Justice Joe said last night. We can't get there if we don't have good teaching. So what we're trying to do with this project is create a resource that will underpin good teaching. So I'll do a little bit of an introduction to Te Rauhī i te Tikanga, a Tikanga Companion. I want to look particularly at Rahui as a ritenga that protects people from the dangers of the sacred. And then I want to look a little bit at the interface between the practice of Rahui and the New Zealand legislation, or New Zealand legal system that underpins it, particularly looking at enforcement. So we'll see how we go and see how we go with time. So the context, the prelude to locate this kōrero in is, of course, Article 4 of Te Tiriti, the oral article that was appended as a kind of bit of an afterthought thanks to Bishop Pompallier, who requested that the natives might be informed that all who should join the Catholic religion should have the protection of the British government. Hobson agreed with this, and then Henry Williams wrote out this little addendum to the treaty that we've long known now as the fourth article. E mea ana te kāwana ko ngā whakapono katoa o ingarangi o ngā wetere ana o Roma me te ritenga Māori hoki e tiakina ngā tahitia e ia. So the several faiths of England, of the Wesleyans of Rome, and also Māori custom. The reason I wanted to use this was because of the reference there to ritenga Māori, or as it's put in the English there, Māori custom. So I wanted to start here because of where we are. And I want to also hark back to some of Moana's words from a very old article he wrote back in 1990, the criminality and the exclusion of Māori. He was writing about what then, in 1989, was a proposed new bill to fundamentally change our criminal code. And of course, there was nothing of Māori thinking, nothing of whakaaro Māori, nothing whatsoever that could reflect Māori thinking on criminality, on hara, on punishment, or any of those things. And he said his description of Article 4 Well, he said, Article 2 of the Māori version of the treaty guarantees the right of rangatiratanga over taonga or prized things, and Article 4, the treaty ensures protection of Tikanga Māori, that is, the basic threads of law, religion, language and other taonga which wove Māori society together. Those articles in conjunction recognise the general authority of Māori people to monitor the conduct of their own. In a specific sense, Article 3 reinforces that authority with the provision, or reinforces that authority with the provision that Māori people have the same rights as British people. So, of course, other commentators have said subsequent to that, well, it was an afterthought, we really shouldn't put too much stock in it. But I liked what he says there about pulling those threads together of law, religion, language and other taonga. So an invitation there to read the 4 articles in light of each other. So I'm just putting that there as a context before talking about just how dangerous the sacred is. I was reading, because I was doing a little bit like what Tajo was doing, looking for how often certain words appear in the Māori Bible. And I was looking for Rahui, it doesn't appear, so you don't need to look. But there's lots of references to wahi tapu. There's lots of references to tapu. There's lots of references to other important words of Tikanga Māori in the Bible. So there's very deliberate translation choices that are being made. But there's about 35 or maybe more, there's dozens of references to moments where the presence of God is seen to be so dangerous that it will kill you. It will literally kill you if you are not protected by laws and obey the laws that are in place to protect you. And I wanted to just bring this example to you from Exodus 19:22 to 24. Ko ngā tohunga hoki e whakatatana kia ihua, kia tapu rātou kei auta atu a ihua kia rātou. A ka mea a muhi kia ihua, e kore e āhei te iwi, te piki ake ki maunga hinai. Nā hoki I kauwhau iho kia mātou I mea tai e patia te maunga, whakatapua hoki. Nā ka mea ihua ki aia, haere, heke atu, ka piki mai anō koe, kōrua ko arona, ko ngā tohunga ia me te iwi, kei wāhi mai rātou, kei piki a ihua, kei autā atu, ia ki a rātou. Even the priests who approach the Lord must consecrate themselves, whakatapu, yeah. Or the Lord will break out against them, this notion of this the danger of this uncontrolled force. The Lord will break out against them. Moses said to the Lord, the people cannot come up Mount Sinai because you yourself warned us. Put limits around the mountains, like put a Rahui, although the word isn't used, around the mountain and set it apart as holy. The Lord replied, go down and bring Aaron up with you, but the priests and the people must not force their way through to come up to the Lord, or he will break out against him. This notion of ota, of breaking out, this dangerousness. So there are lots of other examples, and there are quite clear examples of people dying because of the force of the presence of God. And of course, that's kind of woven through many parts, particularly the kind of the first 5 books of the Old Testament. And then, of course, in the New Testament, the narrative shifts in that Jesus himself is the manifestation of the temple. He is the one who tabernacles amongst the people. He leaves his disciples the gift of the Holy Spirit that might leave people thinking you might be drunk and a bit over demonstrative, but its advent will not kill you. So there is quite a shift in the way in which the presence of God is treated across the Old and the New Testaments. And it's very clear by all kinds of historical accounts that Māori have long understood and continue to understand just how dangerous the sacred is, in a way that's similar to how the Old Testament presented this notion of the dangerous presence of God. I just want to pause here to affirm that what I'm going to be saying is also underpinned a little bit by the work of Māori Marsden, who talked in gosh, I think it was 1992 as well, about a two world or possibly three world model, and some of us will be familiar with his writings. The first world, to the extent that it is a three world model, he was a bit equivocal on that. Te kore, te pō, the realm of potential being the realm of becoming. And then te ao wairua, which we also sometimes refer to as te wāhi ngaro. And then te ao marama, or te ao kiko kiko, the flesh, the world of the flesh that we live in. So these precede each from each other, but it's not a closed system. So that te ao wairua frequently intercedes in Māori thought in the world that we live in te ao kiko kiko, te ao marama. So much of Māori law and Māori legal norms and retinga, therefore, are primarily concerned with keeping the sacred restricted, keeping the sacred unto itself, and enabling the rest of us to live our ordinary lives. So just to keep that model, if you like, in mind, it helps with what will come next. Kia ora. So when we start, so Te Rauhī i te Tikanga is this project that I mentioned before, and of course we're starting on the next phase of the research. We've finished our pilot now, and what we did over the course of the pilot was we wanted to kind of identify a working model of Tikanga Māori, and one that could be articulated and one that could be presented and explored by way of a digital resource. So we looked at, and we wanted to go ground up. We wanted to look at particular practices on the ground, how they were carried out and are carried out, because we're not assuming that these practices have died out. So how these practices are carried out on the ground, and how, as our thinking developed, how Māori legal norms, what I've referred to as Māori legal norms, inform the instantiation and the creation of those retinga. So the list that you've got up there on the slide, we're really just looking at the first two, a set of legal norms and legal practices and procedures. So we're talking about Māori legal norms and Māori legal practices and procedures. The others, legally relevant institutions, legally relevant roles, claims of rights and interests, actions or states that incur legal consequences or that result from legal processes. These are all part also of a Māori legal system, our Māori legal system. But for the purpose of where we're at with our project, we're just focusing on the first two. So articulating, identifying this set of Māori legal norms, and then seeing how that informs and precipitates the creation of Māori legal practices and procedures. So what we did was, as I mentioned before, we looked at Rahui as that practice that's ordinary and on the ground. So Rahui is one of the most well-known processes under Tikanga Māori, other than the pōwhiri, tangi, etc., that I think have seeped into the public consciousness. We kept a record, actually, of how many Rahui were being, just in terms of Google notifications, when Rahui are being set, it's bing, 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 bing all the time. So there is what looks to be the coming back into kind of consciousness of the retinga of Rahui. But what we also were interested in, which of the Māori legal norms were informing it. I mean, you can read the sources and make up your own mind, but what we did was we gathered about 300 examples of Rahui. We examined 166 of them very carefully for evidence as to what might people be referring to in terms of Māori legal norms. Now, by Māori legal norms, I'm referring to the kind of great things that actually are rooted in te ao wairua, right? So tapu, mana, whakapapa. We could all probably name a set of about 10. They seem to repeat time and time again, but certainly one of the things that marks them out from me, and I kind of tend to see them as great driving principles. There is this connection with Te Wairua that's very clear. I think, well, going back to Māori Marsden, in the case of tapu, for example, it's been described as a spiritual institution set up for political purposes, as a form of social contract, regulating behaviour and setting behaviour standards. Māori Marsden talks about tapu implying an enforceable obligation. He uses legal language. He says that it suggests a contractual relationship that's been made between the individual and his deity, whereby a person dedicates himself in return for protection against malevolent forces and power to manipulate his environment to meet the needs and the demands of people. So that thinking about tapu I think is deeply important for Rahui, which I'll get to in a moment. That's a picture from one of the sources that's set in Alexander Turnbull Library. It's a postcard. It's about tapu. It's got 4 panels on it, but all different instances of natives and their tapu. And this is just one of the details from that particular postcard, which is just showing a rangatira tying a string around a tree, which is a way of marking off that tree as being tapu. There's a contact with or use of that tree as being forbidden. So we interrogated these examples for of Rahui, and of course there's more than one category of Rahui, right? So for those of you who are not aware of what Rahui are temporary bans or prohibitions. Well, they're usually temporary, but sometimes temporary can last for many years, even over a century. So, but for the most part, they will be temporary bans, as opposed to, or rather than wāhi tapu, which are often in place for centuries. A Rahui will be often more of a temporary phenomenon. And so what you have there on the screen is 4 categories that seem to really represent the kinds of Rahui that can be imposed. And they look like they're not entirely connected, right? So in the case of political ownership, Rahui being used as a way of asserting ownership of land, asserting ownership or use of particular resources, asserting the mana of a hapu or an iwi over a particular area. Pa Tate in Karangahokianga talks about an example of this kind of Rahui where there had been tensions between Moetara and Muri Whenua over a number of issues to do with the whenua. Ngāti Korokoro began to make their presence felt by building canoes at Motukauri. But Muri Whenua had these canoes destroyed. Ngāti Korokoro dug drains to establish boundaries, and they too were destroyed, filled in actually by Muri Whenua. Muri Whenua then established reservations for the area to discourage Ngāti Korokoro from coming onto the land. So there's examples there of prohibiting the use or access to certain things in order to assert ownership and rights. In the case of death, which is where you may have heard about Rahui if you're not familiar with the phenomenon, it's not uncommon in the news to hear, and the most obvious public example of this would have been Whakaari, White Island, where 18 people died after the explosion, and a Rahui was immediately placed around the environs, but it only lasted a couple of days, I think, whereas some Rahui placed over water can go for years and years, depending on the context of that particular hapu or that particular iwi. So, and just in regards to Rahui in the case of death, often this might be referred to as a kind of like a pollution Rahui. So where there's somebody who's passed away, their tūpāpaku is considered to be highly tapu and actually highly dangerous and also potentially contaminatory of, resources. So that's part of the reason for establishing a Rahui. And so sometimes it can be named as a pollution Rahui because of the danger, right? So harking back to this notion of dangerousness. Probably the most common category of modern Rahui would be the conservation Rahui. So Rahui placed to enable certain resources to recover their strength where they've been depleted. There's quite a few examples of this. I'm going to talk about a couple of them shortly, but can't seem to... Oh, here we go. What was I going to say here? Right, so a highly relevant factor to consider and a norm to consider in the development of Rahui in the case of conservation is the protection of Māori. Oh, really? 15 minutes, okay. Protection of Māori. So the Māori being the life essence or the life force of a particular resource is depleted. The placement of a Rahui enables, under certain circumstances, for that Māori to flourish again and therefore for the resources to then flourish and regain a better form of life. So Māori becomes highly relevant to the imposition of a Rahui in the case of conservation. One other that I want to just touch on, to control specific behaviours. This is much rarer, but it does happen, and Herenga Mokomita is to blame, for some of it at least. He suggested in 1972 putting a Rahui on, I think, was it players to go to South Africa to play the South Africans, that there should be a Rahui placed on players to prevent them going. I can't quite remember whether he wanted to put it on the Māori members or all the members to prevent that. He was also deeply instrumental around the same time for the creation of a national Rahui against drug use. He called for a national Rahui against drug use. Māori churches took that call up, actually. They designed a logo and everything because of the amount of Māori that were getting convicted for heroin use. So in the year after the passage of that Rahui, there were almost no convictions for heroin use, but still other convictions for other types of drug use. So that is really about prohibiting certain kinds of behaviour, but it's not linked to a territory, it's not linked to a place. But to control certain types of behaviour instead. I've mentioned these 166 examples. So we looked at each example and we actually scored them for evidence that mana, tapu, Māori, wairuatanga, whakapapa, whanaungatanga, the kind of the big 10, that those driving norms were being referenced or could be necessarily inferred in the sources that we were looking at. And what you see there in our radial dial is that quite clearly mana and tapu, as opposed to others, were most prominent in regards to the placing of a Rahui. Now this is only in regards to the ones that we looked at, and we can build that database bigger and we can reanalyse it and see if there's any changes, but this was quite consistent. Mana, the authority to place a Rahui, that was often talked about in the sources. And of course tapu, the control of tapu, and also the imposition of tapu to prohibit the use of resources, etc., etc. So this idea that there's two major leading Māori norms at work in the creation of Rahui. That doesn't mean that there aren't others that are relevant. You'll see on that radial dial that wairuatanga and also Māori, which we labelled differently, and it's not in this particular label. Whanaungatanga, kaitiakitanga. You expect kaitiakitanga to make an appearance, right? Because especially in the conservation Rahui. But that wasn't necessarily a lot coming back in the sources. It was most of the evidence that was coming back was reference to tapu and reference to mana. But again, those other norms are all, you can't separate them out. They are all interlinked. Where the tire really hits the tarmac, though, in the modern context with regards to Rahui, and the examples that we took were, we made sure that they were representative of 19th century, 20th century, 21st century, geographically as far as we could. So it was a reasonable sample, not exhaustive, but a reasonable sample. But like I say, where the tire really hits the tarmac is the matter of enforcement. So Rahui as a ritinga based on the exercise of mana and tapu and the upholding of Māori, for example, were not often enforced by direct human means. The understanding historically and traditionally was that Te Wairua, from whence these legal norms came, that Te Wairua would also take care of the enforcement. That doesn't mean to say there weren't also human actions as well, but certainly this idea of punishment for the breach would come from the divine, which again harks back to that nature of the presence of God being so dangerous as well. So some commentators have identified Rahui with teeth and Rahui without teeth. In other words, some Rahui that could be placed with particular strong karakia, and other Rahui that would not necessarily have to have a karakia in order to be placed, just a rangatira to say, or a people to say, you can't do this in this area, or you can't carry out that behaviour. So this idea that a Rahui with teeth, with the strong enough karakia, would ensure punishment from Te Wairua. Rahui without teeth, well, it's left up to you as a moral obligation. Well, it's still a legal obligation, actually, but not necessarily one that will be enforced from Te Wairua. I just wanted to... I am coming down the back track, I promise. This is a... I really enjoyed this notice. This is from Te Puke ki Hikurangi. This is the official newspaper of the Kingitanga. And it's a publication from 1905. And unusually, it's a woman's voice. So most of the sources that we came across were about men, by men. There was only a couple, really, that involved women. Some very famous Rahui involved women, of course, Muriwai being one. But in terms of a woman's voice being direct, this is a notice. You've got the Māori up there. I'll just read the translation. Notice to the women cutting flax. The home of my men at number 1613 of Papawai, the flax of that place are things absolutely under absolute Rahui. Although all the harakeke of some blocks of that place have been sold, the Rahui does not apply to the knives of the Pākehā. I just heard about the flax of that place being used, and I went to see. The first thing I saw, the bundled flax lying, heaped, dried at the base of the plant. I saw this cut flax cut off from the source, this big place left to stand abandoned. Going there to gather flax must stop. Beware lest the person be penalised for trespassing that place and using the harakeke. Interestingly, in 1905, 2 weeks later, the notice, this is, did I say the name? Horiana Takanakingi, very well-known rangatira in her own right. She placed the same notice, but the last sentence said, me mutu hoki te haere ki reira mahi harakeke ai ki te kite e au te tangata, tāne wahine tamariki rānei e haere ana ki reira tapahi harakeke ai, ka painatia e au ki te moni e rima pauna. So basically, this using of the flax must stop. Women, men or children, well, men, women or children going there and cutting flax will be fined by me the money of £5. So this is interesting. It's not an assumption that Te Wairua is going to take care of it. She has the mana to impose a fine, a Pākehā punishment, if you like, for the breaching of this particular harakeke, Rahui. And so that's 1905. It's a relatively quite early example. But what we have seen in the intervening century and a bit is a gradual recognition by legislation of Rahui. And the question then is, what is it the legislation that Pākehā law, if you like, can do in the recognition of Rahui? And if we could have the next slide, please. Kia ora. This is just a few examples. And Fiona McCormick, when she writes about this, and I think so does Jacinta Ruru and Nicola Huyn, when they talk about this, they see the recognition, even not necessarily with using the word Rahui, in legislation is a weakening of that particular Rahui. So to take an example, we've got Section 186A and 186B of the Fisheries Act, 1996. You may be familiar with that. Those are the provisions that enable the establishment of temporary bans on fishing. Doesn't use the word Rahui, but those are the provisions that people will often work with MPI, Ministry of Primary Industries, to ensure that a Rahui that might be customarily placed according to Tikanga Māori can also then be enforced under legislation, because there can be fines levied. There's all kinds of palaver about what you need to do in order to get it set up. But there are other regulations and bylaws and things where Rahui can be recognised in some form or another. But of course, there is differences in how Rahui are understood under Tikanga Māori, and how temporary fishing bans, for example, or temporary bans over a particular area are recognised under the general legal system. And of course, the general legal system is not capable of recognising the spiritual basis for the operation of those Māori legal norms that I've talked about. I just wanted to give a couple of examples of conservation Rahui, because one's been in the news. So on the left there, you'll see Mahara Okeroa, and he was behind the establishment of a Rahui over the taking of seafood along the coast between New Plymouth and Opunake last year, and has just won an award. He was in the news night before last night. A Taranaki Regional Council Environmental Award, because there was a Rahui placed, and he talks in the interview about how what he used to be able to access when he was a child, and then walking along the coastline and seeing so many people out there gathering kai, and there's not enough and it's all too small. And so he established, along with his people, this Rahui, but then also went to MPI, and there was established a temporary ban as well. So you've got the two systems working in twain, if you like. Māori customary law, or Māori law, and the fisheries ban. And that's quite interesting when you look at the one on the right. Now, the one on the right is referring to is a photo of the placement. I think it was actually the replacement of the po Rahui, so the carved po in the Taurua Rahui, which is on Taurua Peninsula on the west coast. Just up at Ahipara, and I don't know if he would allow me to talk about him saying this, but I'm going to say it anyway. I was talking to I was emailing Hami about this Rahui the other day, Hami Piripi, because he was the one who did the karakia to establish this particular Rahui, and he emailed me something really interesting, which I thought I would share, even though I haven't asked permission, so he'll probably give me a thwack at some point. But he talks, I didn't ask him this, but he talked about the shift in theology behind what he wanted to achieve with this Rahui. So just bear with me. The methodology and I guess the theology of our rituals began to change from a pantheon of deities to the one-stop shop atua, which could relieve you of your sins and avert the law of the universe, where every action demands a reaction. So over time, the nature and understanding of tapu has adapted to follow the theology, and over the last 100 years or so, the essence of tapu has diminished, to the extent that when Rahui were put in place, they simply became a Christian blessing ceremony. This is particularly apparent in engaging with natural resources and phenomena. When we did the Rahui at Taurua, I studied for over 6 months to try and construct the karakia that would enable us to say the Rahui was held in place with real tapu. I'll leave it, I won't say the rest of it, but that just gives you an idea of some of the challenging thinking. How, if we're involved in Tikanga Māori, how do we hold Christian thinking, Wairua Māori thinking, and not. I don't think this was necessarily a problem 100 years ago. I don't think Horiana Kingi was particularly exercised with it, but we are now. So this leaves us with some questions. He also does say that he was supported in the placing of that karakia by clergy. So, I don't know if you were there, Bishop.
No, I wasn't.
This is in 2009, so it's quite a long-standing Rahui. Some people have complained about how long-standing it is. So, yes, I don't quite know how to conclude. I never got around to a conclusion. But it's not enough to just talk about Rahui as being humdrum and earthly and practical. That is absolutely true. But it has sacred roots. Those roots come from Māori legal norms that are sourced into our wairua. And so we need, if we're going to be teaching about Tikanga Māori, we as law teachers, we need to understand that and not teach some kind of, and that raises all kinds of issues and presents all kinds of dangers, but it's becoming increasingly obvious to me as we go through this project that we cannot put those sacred things to one side or pretend they don't exist. So it does have implications. And we can't expect legislation to uphold, or case law, to uphold the sacred aspects of Rahui, for example. But it is apparent that over the century we've become more and more willing to use the tools of the Pākehā to achieve what we want under Tikanga Māori as well, at least in regards to Te Rauhī. I'll leave it there, I'm probably about 10 minutes over. Aroha mai. Tēnā tātou.